So welcome to this webinar as part of our special Law Week series. This webinar is being recorded and will also be available on the Legal Aid YouTube channel. Before we start, I would like to acknowledge the traditional owners of the land I am on today, the Gadigal people of the Eora Nation, and pay my respect to elders past and present. I also like to acknowledge that Aboriginal people are the first educators on this land, as we are doing this as a community legal education session. The purpose of this webinar is, in Law Week, to make the legal system more understandable, less intimidating for some of you who might not have had as much to do with the legal system. And it really provides such a unique opportunity to ask questions to members of the legal profession. So like I mentioned before, please use that Q&A function. Only us as the hosts can see your questions. Not everyone can see them. And you can also ask questions anonymously. So we really encourage you to ask questions. And we'd really like you to, ask questions to these amazing people that I'll introduce you to in a minute. And hopefully you can find out a little bit more about our legal system in New South Wales after this session. So I'm just going to ask you to go around and introduce yourselves very briefly. Firstly, I'm Natalie. I'm from the Community Legal Education branch at Legal Aid New South Wales. Your Honour, Magistrate Hayes, would you like to go first? Introduce yourself.
Thank you, Natalie. Paul Hayes is my name. I'm a magistrate who currently is sitting at the Children's Court. I'm on Kamilaroi country at the moment in Moree. Kamilaroi comes about as a result of some Aboriginal wording around the land of the water hole and the rising sun. And it's certainly a gorgeous day in Moree today. The Children's Court work that I do is mainly Children's Court crime and what we call care and protection work. Care and protection work involves decisions around whether it is in the best interests of children that they be removed from family or remain in family. If they are removed in family, then they are placed in out-of-home care, sometimes with kin, other family members, and sometimes with foster carers, both short-term and then on a more permanent basis. Thank you, Natalie.
Thank you, Magistrate Hayes. We look forward to hearing more about your work today. And Jeremy?
Good afternoon, everybody. I'm Jeremy Atkin. Thank you, Natalie. I'm a barrister at Sir Owen Dixon Chambers. I practice primarily in crime or things that are closely related to crime. I appear in a range of courts and, when lucky enough, before His Honour Magistrate Hayes.
Thanks, Jeremy. And Danny?
Good afternoon, everyone. My name is Danny Shaw. I'm a lawyer at Marrickville Legal Centre. I've been here for about 5 years, and at present I mainly practice in the area of crime in the local court, in some other associated areas in relation to crime. I've also had extensive experience in working in another community legal centre, where we assisted people with Centrelink or social security problems. So I can draw on that experience to answer questions here. And I've also had a short period in Aboriginal Legal Service where it was primarily to do with crime.
So it's just happened that everyone works a lot in crime today. If you wanted to find out more about other areas of law, like family law and civil law, you can watch the recorded webinar that we did with some legal aid lawyers. And also on your screen, we have Donna, who's our Auslan interpreter. So thank you, Donna. Okay, I'm going to show you some slides now, and I'll describe what's on the slide, and then I'll ask a few questions. The first slide is a little bit more about Magistrate Paul Hayes. So the first picture you can see on your screen is, some of you might recognise Judge Judy, an American TV show, and I guess that's a court sheriff standing next to her. And the other picture is from a TV show that you might remember from several years ago called Sea Change, with a magistrate who looks like she might be in her chambers or her office. So, Magistrate Hayes, my questions for you are, can you explain what's the difference between a magistrate and a judge? I assume you often get called judge, so please explain the difference, and also that difference between the work you do in court, when you're in court, and when you're in an office or in chambers, which it looks like you might be at the moment as well. So just describe a little bit more about the work you do.
Look, thank you, Natalie, and thank you for the pictures too. It takes me back. I used to love Sea Change, and I thought that magistrate had a really gorgeous behaviours in court, respectful to all people. I think that contrasted significantly from Judge Judy, who was quite intimidating.
Judge got it.
Yes, I don't think she was a real judge, was she? She certainly didn't seem to behave the way that a judge ought to, other than she was able to make decisions. So the main difference between a magistrate and a judge relates to what we call jurisdiction, and that is that the powers that magistrates or judges have, and the sort of work that they can do. For example's sake, magistrate does some family law matters, but in a limited way. The majority of family law matters are dealt with by way of a judge at the family law court. In relation to civil matters, the local court magistrates do a number of civil matters, sometimes in the small claims or in the general division. Magistrates can make decisions in regards to claims up to a sum of $100,000, whereas a judge can deal with matters up to the value of $750,000. I think that's still the case. There's a difference then between a judge and what we call a justice, and judges of the Supreme Court and judges of the High Court are generally called justices. So that's another category of judicial officer. And of course, a justice in the Supreme Court deals with matters in excess of $750,000. Judges in the district court can deal with all traffic or road-related injuries and claims, even if it's in excess of $750,000. So in relation to civil law, there are those jurisdictional limits. The local court, $100,000 or less, a district court judge, $750,000, and above that, the Supreme Court. In relation to crime, again, there's also jurisdictional limits. The magistrate will deal with matters, for example, say in the children's court, for matters that can carry up to 20 years by way of a control order or juvenile imprisonment. If one doesn't understand the concept of a control order, it's like imprisonment for children. The local court magistrates can deal with a range of different matters. Some of those more serious matters, though, go up to the district court. And of course, some, for example's sake, those matters that carry life imprisonment, such as murder, will go to the Supreme Court. There are jurisdictional limits, what we call a limit in relation to offences, both in the children's court and the local court. There's a maximum, in a general sense, 2 years for any single offence, and then that can be accumulated for a number of different offences, up to generally 5 years. So in essence, the more serious matters go to the district court. The less serious matters can remain in the local court or indeed the children's court. All matters generally commence, though, in the children's court or the local court and progress their way up to the district court. Matters are vetted in the local court to see whether indeed there's enough evidence for those matters, more serious matters, to go up to the higher jurisdictions. And look, that's a broad brush in regards to the difference between magistrates and judges, Natalie.
Thank you. No, I really appreciate your response. Okay. So humour me now. There's a bit more descriptions of a barrister now. So Jeremy Etkind, This picture you might recognise is from another Australian TV show called Rake that featured a barrister. And I have another picture up which people might remember from our COVID times when courts moved more online. And this is again from America, where apparently a lawyer's image got stuck on a cat filter. So Jeremy, my questions for you are, I guess similar along the lines of what's the difference? So what's the difference between a barrister and a solicitor? And I guess we use the term lawyer often interchangeably with solicitor and lawyer, but lawyer is a bit of a broader term. So what's the difference between a barrister and a solicitor? And we're looking at the picture from Rake. He is wearing a wig and a gown, and I think it's called a jabot. So is that how you always look in court? Do you always wear that? And I guess my final question is, do you appear in court remotely now as well, like over technology, or are you always in person in court? Thanks, Jeremy.
No problem. It's exactly like Rake. I'm a barrister. The barrister and a solicitor are both lawyers. We're just really different kinds of lawyers. Most barristers were solicitors. I was a solicitor for about 10 years before I went to the bar and I became a barrister. With the clothing, the dress-ups, the theatre of it, that is what we wear. We wear the wig and the jabot and the robes, but we wear those only in certain courts. So when I'm in the local court or the children's court, the magistrate will be in their robes, but I won't be. I'll just be in my suit and tie, as I'm in today, because I'm in the children's court today. When I'm in the children on the local, you won't be able to tell. We'll look the same and dress the same as the solicitor. When we're in other courts, for example, the district court, that's when we wear all those clothes. And so yeah, that's basically the clothing. We get to dress up and have a bit of fun with it. With the online court, it did happen quite a lot during COVID. That cat thing was a real thing, I think, in America, which highlighted some of the pitfalls of it. My preference is not to do things by Zoom, only very small mentions if it'll save a client costs or something like that, then I'm happy to do it, or if I need to fit something in. But anything in which you need to be persuasive, I don't like to do it, because ultimately the role of your lawyer, the solicitor, or the barrister is to be an advocate and to advocate for your case and try and persuade the decision maker, whether it's a magistrate or a judge. And I find that it's a lot easier to do that in person. You can be more effective. So it's generally my preference. So what were the other?
Thanks, Jeremy. No, that's really good. I think that's a great start, and we are going to have more questions for you later on. But one of the questions we had in advance was actually, I think you've answered before, about how soon after you graduate as a lawyer can you become a barrister. So I guess it varies, but your experience is, yeah, solicitor first.
That really depends on you. You can do it straight away. There's no real technical barrier if you're willing to sit your exams and if you're up to it. I wouldn't necessarily encourage it, but it's possible. I think the average is probably about maybe 7 or 8 years or something like that, but all ages, all people go to the bar at different stages of their career if they want to. So you really can go anytime, but I was about 10 years as a solicitor.
Right. Thanks, Jeremy. And Danny, okay, for you, we've got another picture that people might recognize. So this is well, I think she's a solicitor, although that might be, I don't know if that's controversial, but the show is called Fisk. So she looks like she's in a private lawyer, maybe a suburban law firm. And then we've got the solicitor in Rake, there was a barrister character and also a solicitor. His name was Barney, and it looks like he's sitting in court. And in Fisk, she's in an office. So my questions for you are, can you describe the work you do as a solicitor? And you work in a community legal centre. So what's the difference between a community legal centre and what we can see on the screen maybe as private lawyers?
Okay. The main role of a solicitor is to interview clients, have an understanding or get an understanding of their legal problem. And sometimes they don't have a legal problem, but the person may think that they do. If they do have a legal problem, work out the best way forward with that by providing advice to the person. Maybe it's necessary to research the law. And then, if appropriate, represent the person in tribunals if we don't require a barrister, or in many cases, the local court. So the nuts and bolts of being a lawyer on a day-to-day basis would be speaking to clients, working out their legal problem, giving them advice about that, advising them of the best way forward, and then assisting them as appropriate. And if it may require getting in contact with a barrister about the matter, to have a barrister represent them, or in more simple matters, we may be able to represent them in a tribunal or at the local court. That's the main thing that a barrister does most of the day. That's what I was doing this morning. I was at court, duty lawyer service. People were coming to us. They had issues in the local court, and we would provide advice, and then I provided some representation today. That takes up most of the time of what a solicitor does on a day-to-day basis. In a community legal centre, there are some other things that we do. We have a responsibility also to provide education to the community, to explain what the law is about, and to inform them of legal processes and the law in different areas. We work on law reform in community legal centres, so where appropriate, we'll take action in relation to trying to change the law. Community legal centres, and I've worked in for about 20 years, have we play a large role in training law students and new solicitors when they enter the field of the law. And in all community legal centres, everyone would do a lot of admin work. So they're the main functions that we do in, say, community legal centre, or even when I work for Aboriginal Legal Service. I haven't worked in private enterprise in the law. The major difference I would be thinking is that we provide a service that does not cost anything to the client. So it's a free service, but in private firms, it's a service where a person has to pay for that, and a lawyer has to bring in a certain amount of fees on a yearly basis. I can see that as the major difference.
Thanks, Danny. So what I'm going to do now is close the PowerPoint slides. So now you should just be able to see us on the screen, and we're going to keep going with our Q&A discussion. There are some questions coming through, and we will address those. But I'm curious, just in a few words for each of you, can you describe, and some of you might have touched on this already, but Magistrate Hayes, what does a typical workday look like for you?
Thank you, Natalie. Before I get to that, I just want to say how honoured I am to be sharing on a panel with Danny and Jeremy. And after listening to both Jeremy and Danny, I sort of realised that they are both appearing for usually those people who are more vulnerable, those persons who have been accused of criminal offences or find themselves in conflict with the law. And I was reminded by your graphics, which I really enjoyed, Natalie, but I used to enjoy Law and Order, which I'm sure would have had its own graphic. And Law and Order used to always begin with that there are two sides to a criminal justice system, those that investigate and those that prosecute. And I used to yell at the television, what about those that defend? It is an honour both to have Jeremy and Danny, and I recognise the wonderful work that they do, and it's essential work. So what was the question, Natalie?
Well, what does a typical day look like for a magistrate? I guess that's a question, you know, we can't get to ask a magistrate.
My day begins very differently, because Jeremy and Danny have to stay up the night before and get up early in the morning to prepare their matters. I don't have to do that. When I come into court, I usually know nothing about the matter. I might have a court attendance notice, which is like a charge sheet. It might have the date of birth on the person. It'll have the charge if it's a criminal matter, and it will allow me to look up that charge matter and see what the maximum penalty is, or see what the elements of the offence are. But other than that, I know absolutely nothing. So my day always begins really, really well. It's as the day progresses that it becomes more difficult, particularly in relation to decision making.
Thank you. And I'm going to ask a follow-up question from before. You were talking a bit about the different types of courts. So local court and district court, and children's court. So we've got a question from the audience, and also we had a question in advance about, can you explain a little bit about the youth query court that I believe you work in, and also if magistrates in New South Wales participate in circle sentencing?
Look, thank you, Natalie. And of course, there's the coroner's court too, which falls under the arm of the local court. The youth query court, it's a great privilege to sit in the youth query court, and it's aimed at Aboriginal and Torres Strait Islander children in conflict with the law. It's a different style of operation, though it's still within the criminal proceedings procedures that we need to follow. The concentration of the focus is in regards to what causes the problem. So a child's in trouble with the law, and typically we have a 13-year-old child, 2 a.m. in the morning, drunk as a skunk with a couple of mates, and they throw a bottle of beer through a glass window. And then the police come and they're charged with property damage offence. And then you might have hours and hours of discussions in regards to, by way of a hearing, whether the kid was there, whether that was the child that threw the bottle through the window, or whether another child that threw the bottle through the window, whether it was done recklessly, whether it was done deliberately. And you might spend 2 or 3 hours. And I'm just sort of sitting there thinking, but what's a 13-year-old kid doing drunk as a skunk out at 2 a.m. in the morning? So what the youth query court does is it puts the property damage or the offence to the side and concentrates on those sorts of matters that led to the young person being out and about. So maybe there's not a safe home, so accommodation becomes an issue. Why are they intoxicated? Maybe there's drugs and alcohol issues. We should be looking at the rehabilitation in relation to dealing with alcohol issues. It might be because they have no pro-social persons that they can fall back on. They might be drunk because they've got this huge amount of debt for transport style offences. So what we try and do is we organise accommodation. We can organise OPAL cards at a very sort of micro level. We can organise some drug and alcohol counselling. If there are mental health issues, we can put them in touch with mental health issues. But particularly in relation to Aboriginal and Torres Strait Islander kids, we connect them to culture. When they understand their place and the powerfulness of their culture and realise that they have got a very significant place in the world, then that can actually change behaviours. So the youth query court is about changing behaviours, and at the end of the day, recognition to the young person by way of a graduation, celebration if they get through the youth query court, and then of course a sentencing exercise for the offences, but take into account the demonstration of rehabilitation that they've shown. So that's a little bit about the youth query court. We do circle sentencing in the local court in some areas. So I've done a little bit of circle sentencing in Dubbo. That involves elders, probably in a little different a way than the youth query court. The elders are there to provide their cultural knowledge. In the circle sentencing, they become involved in the discussion of penalties. And I found that the elders in circle sentencing can be a lot harsher, a lot tougher in regards to Aboriginal or Torres Strait Islander persons than, for example, say, me sitting there, part of that circle sentencing exercise. Thank you, Natalie.
Thanks, Magistrate Hayes. There's 2 more questions for you from participants before I move on to the others. So one of them is, and I think I'm going to know I know the answer to this, but what do you do if you're in 2 minds about a decision, guilty or not guilty?
I'm never ever in 2 minds. You can't be in 2 minds. The justice system only works because somebody makes a decision. The justice system would be useless if somebody could not make a decision. So you make a decision. But you're really helped with the law, because with the law there's 2 fundamental things that I always begin with. And one is where the onus is, and that is the person who's got the responsibility to prove what they are attempting to persuade the court on. So they bear the onus. If they can't do that, then the matter is dismissed. The second thing is this burden of proof. So, for example's sake, in crime, it's beyond reasonable doubt. It's a pretty high burden in that sense, or a pretty high onus. And in relation to civil proceedings, the standard is on the balance of probabilities. So you can look to both where the onus is, who has got the responsibility for establishing something, and then that standard. And once you've looked at those carefully, you are obliged, and it's easy to make a decision.
I was thinking beyond reasonable doubt. That's what you were going to say. And another question is a bit more of a personal question of how long did you practice law before becoming a magistrate? What was your path to being a magistrate?
Gosh, look, it would have been more than 20 years. Yeah. So a lot of that time was, in fact, at Legal Aid New South Wales, the Legal Aid Commission, which was an absolutely wonderful place to work. The intrinsic value that you get from helping the most vulnerable in the community is really priceless. But I think that now they've got a minimum of, I think it might be 8 years in practice before you can apply to the bench. There is a period of time that I think now is set by way of minimum practice.
Thank you. There are some more questions, and I will come back to those, but I'll move on now. So yeah, we've talked a bit about different types of courts, but also, Danny, you mentioned you work a lot in tribunals. So we did have a question in advance about, we call it NCAT, or the New South Wales Civil and Administrative Tribunal. So what's, I guess, the difference between a court and a tribunal, and what types of matters have you helped people with in tribunals?
Okay, thank you for the question. I have represented in the NCAT, which is New South Wales Civil and Administrative Tribunal, but I've also have much more experience in the Federal Tribunal, Administrative Appeals Tribunal, or the Social Security Appeals Tribunal. The matters I'll talk about 2 things. The major difference, is what I can see from also having worked in the local court, is there's 2 major areas. There's less formality in the tribunals, and so that comes out in different ways. No, so formal. We don't call people honours in tribunals. There's no other staff in the room when we're speaking to the tribunal members. It could be 1 or 2 tribunal members, and they're sitting across a desk from where we are sitting. So it's much less formal than courts. The other major thing, and I don't want to get too lawyer here, is there's a thing called rules of evidence. And in tribunals, the rules of evidence don't apply as they do in the local courts. And the rules of evidence are very tricky, one of the more tricky things for lawyers, But in tribunals, because they don't apply, it makes it much easier for people to represent themselves or for a lawyer to prepare cases on behalf of clients. They're the two major differences I see in tribunals. I've represented primarily in the area of social security law, so the types of cases there are relatively, or I think quite serious cases. The two major cases we represented in when I worked in the previous centre would be where a person incurs a significant debt to Centrelink, and the debt could be, I've represented in debts of over $100,000, and we're putting an argument forward or advocating on behalf of the person that it was incorrect for Centrelink to have raised that debt. And, the person's already vulnerable, they're in receipt of Centrelink, and they may have a lot of other things going on in their life. But we would have to put forward the case that the debt, one, should not have existed, or secondly, it shouldn't be recovered if it wasn't correct to raise the debt. Other types of cases at that tribunal, the Social Security Municipal Appeals Tribunal, where Centrelink, the government, has decided not to pay a social security payment, a Centrelink payment to a person, could be youth allowance, New Start allowance, disability support pension, or age pension, no matter, for a variety of reasons. I won't go into those because it's rather complex and finicky. But if the person's not getting paid, they may have no source of income, may have no support, they may be staying in a women's refuge, a youth refuge, maybe staying in their car, put up by friends, and we would put forward the case that the person should be paid the Centrelink payment. And it's a complex area of law, so I won't go into the complexities of it. So they're the types of cases that I've represented in many times when working at the previous centre. At NCAT, I've been there a couple of times, and that was primarily over freedom of information requests. So we were seeking information in a couple of cases, from New South Wales Police, who failed to provide that information to us. So we would then go to the NCAT to argue the case to say that we should have access to that information.
Thanks, Danny.
Yep.
Some good examples there. I'm going to ask Jeremy a couple of questions now, and then there are quite a few questions coming through. So, and you might have explained this a little bit, but with barristers, so you're often instructed by a solicitor, but are there times when the question was, do barristers work with self-represented litigants? But I'm assuming that's the term that means the person's representing themselves in court. So I guess you could talk to that. And also, do you represent people directly, or do you always work with a solicitor?
Certainly. Firstly, I should say, if you have questions for Magistrate Hayes, you should definitely take advantage of the opportunity of having him there. You can grab Danny or I on the street one day, but it's a privilege to have his honour part of it, and you should maximise that. Generally, I'm instructed by a solicitor. That could be a solicitor from Legal Aid or the Aboriginal Legal Service, or a private solicitor. Certainly, if I'm in the district court before a judge, or in a jury trial where we're wearing the robes and the decision maker is actually not the judge, but the jury of 12, I would definitely have a solicitor instructing me. They have most of the contact with the client. I still have some contact with the client, but they're really the main client focus there, and they brief me and instruct me to appear as the advocate in the matter. I do some direct access matters. I won't do, it's up to a barrister whether they do direct access matters or not. By that I mean when there's no solicitor in the middle. I generally won't do them in private matters. I'll insist on having a solicitor instruct me. But in legal aid matters, I'm committed to that work. I was at Legal Aid for 6 years. I was at ALS, Aboriginal Legal Service, for a few years. So I'm very much committed to that work. So I do those matters, direct access without a solicitor, quite a lot. But otherwise, I always require a solicitor.
Okay, this is a question for both you and Magistrate Hayes. I'm not sure if you want to answer it, but the question is, have you ever regretted representing a person? No comment. No comment.
I must admit, I was thinking, and I'll be intrigued to hear what Jeremy says, but I don't think I ever regretted it at all appearing for people. I've sometimes regretted making the arguments that I did on behalf of people, but no, I can't think of, and I know that there were some people that were very, very scary, but never have I regretted appearing for an individual. Jeremy?
Look, it's a really interesting question. My answer is definitely not. Same with Magistrate Hayes. Absolutely never regretted acting for a person. I would act for anybody, no matter their crime. If anybody's charged with an offence, it's at that stage an allegation, and it's a primary importance in our system that they have a representative, and that's a representative that needs to bring no judgment to them. They just need someone to be able to objectively, so to assess the evidence and assess the law, but otherwise to stand in their corner and make their best arguments for them. If we start to bring judgment to our clients, then you might get lawyers not wanting to represent clients, and then you get a whole systemic problem, I think. So definitely not. But certainly I could not agree with Magistrate Hayes more. There are many, many arguments that I wish I hadn't made. In every matter, often there's something that as soon as it comes out of your mouth, you wish you could pull it back, but you just can't. But you learn from it and hopefully you do a better job for the next client.
Never before me, Jeremy. You've always been absolutely superbly spot on.
Very grateful for that. Thank you, Your Honour.
There was a question before about the difference between these court hierarchies at the local court, district court. And I think you described that before about severity of matters determines the jurisdiction. And there's also an appeals process. You appeal from one court to the higher court. The person's also asked and this might be the person from the ACT, because they've said, what's a magistrate's court? And I think the local court in the ACT is called the Magistrates Court. And I think we won't go too much into that, describing different courts. And there's also a question about what are the rules of evidence. But what I'm going to do is keep those questions, and maybe we'll do a further webinar describing more about the laws in New South Wales and the laws in Australia. And like you said, Jeremy, I think we'll take advantage of the people we have in the room today to ask you the questions. So thank you for those questions, and we'll come back to those in another webinar. So I'm interested, Magistrate Hayes, and I guess because we're fortunate enough to have an Auslan interpreter today, and I know we've got a lot of people who are interpreters in our webinar today. So can you describe what's your experience of working with interpreters in court? And do you have any suggestions on how can we improve access to justice for people who don't speak English as their first language? And I guess a follow-up question to all of you on that would be access to justice for people with disabilities as well, people who don't have English as a first language. I think we're all really interested in that topic. Thanks, Magistrate Hayes.
Thank you, Natalie. I will say, just to the poor person that asked about the evidence, the rules of evidence.
Oh, yeah.
With most things in law, there's an Act of Parliament, there's legislation in place, and there's the Evidence Act, which sets out rules of proof and admissibility, etc. Look, in relation to interpreters, and that's a good question. Now, I can't see Donna on my screen. If I could see Donna, I'm sure I would slow down to make sure that I'm speaking at a pace that she can sign to. I apologise, Donna, if I have been talking too quickly. The importance, look, access to justice, of course, is really important for the justice sector, but very important, obviously, for the court. The court cannot make proper decisions unless people have got access to justice. And for those that cannot speak English, interpreters play a very valuable role. And obviously the translation is part of that role. But I do say it's a part because it's not the whole. What often happens for those persons where English is not their first language is that they may also be subject to trauma. Persons coming from overseas countries quite often are affected by that. So the court needs to take a very trauma-informed approach to those persons who come before a court, full stop, but with the use of an interpreter. I think it's really important for the court to receive some education in relation to the cultural matters pertaining to the language and the culture of which is the background to a person who's before the court. So there are obviously the fundamentals of making sure that the court allows extra time if there's an interpreter, the logistics of making sure that an interpreter is able to be seated, making sure that the dialect is understood between the person and the interpreter. But as I say, that cultural aspect becomes really, really important. And different people from different cultures react in different ways. They express themselves in slightly different ways. It's very apparent in regards to the Aboriginal and Torres Strait Islander people who many of the time can speak English, but they have got a different approach sometimes to questioning. Certainly in an official police record of interview capacity, there are differences. And sometimes even when cross-examined, when persons have been asked questions, they behave in different ways. So it's not only important to have an interpreter there for language, but also almost an interpreter for culture as well, so that we can better understand, because we can't get to the truth unless we can fully understand what people's experiences were that brought them to the court.
Thank you. Jeremy or Danny, did you have anything to add about your experience for working with interpreters or for vulnerable clients generally?
Well, didn't want to interrupt just in case Jeremy was going to speak, but I can say a few things. I can just give you an example of today. I was at Burwood Court this morning providing a duty lawyer service. Burwood's it's near Strathfield, so it's inner Sydney, and so many people there need interpreters. They actually have a person recently been appointed as someone to organise all the interpreters from the interpreter service, because we have so many different languages spoken at the court. And also with many clients who ring community legal centres need an interpreter, and there's a telephone interpreter service which is invaluable, which we can use at the court if there's not a court-appointed interpreter there. So, and also in general, in relation to vulnerable people, the community legal centres were pretty much set up to assist low-income vulnerable people to help sort out their legal matters. And so the majority of our clients, if not, getting close to 100%, come from a very disadvantaged background. And you need special skills as a lawyer to be able to assist them, to communicate with them, to get their story, to put the law in plain language, to be able to assist them and they understand what their best options are.
Thanks, Danny. And a question, which I think follows on from what you were just saying, is the criteria of who you can give advice to at a community legal centre. So you said it's really set up for people who are more vulnerable, experiencing disadvantage. And you've said you do crime and you've done social security. What other types of legal matters does your community legal centre give advice on? And sorry, another follow-up question to that is, so you represent people in court. So you were talking about legal advice before, but community legal centre lawyers do representation as well.
Yeah, absolutely. I've run hearings. I do sentencing matters in the local court on probably a weekly basis. There's a lot of minor things coming up before sentencing, which we appear in. Also run hearings and in the local court. And most of the, and bail, Aboriginal Legal Service, when they're in, all the lawyers in Aboriginal Legal Service will do bail applications, release applications. So solicitors do appear in court, primarily the local court. Higher courts, we would be employing Jeremy and his friends. It's a good question. I'll just very briefly, community legal centres can be divided into two groups. There is specialist community legal centres, such as the Refugee Advice and Casework Centre, Immigration Advice Centre, and then there's general legal centres such as Marrickville. And Marrickville does a lot of different areas of law. I do the crime and the apprehended violence order and traffic law. We also do employment law. We have a hefty employment law service. We have about 5 tenancy workers. So we provide advice on tenancy matters for people. We also provide advice and representation on strata law, family law. I think that might be it, and some dribs and drabs from other areas of law, but they're the main areas of law that we deal in. And we do have, and legal centres have an income test, but generally most of our people either in receipt of social security, or there's so many people these days who just have casual temporary employment that the clear majority of our clients earn less than $40,000. Most of my clients at Burwood Court need an interpreter, or certainly about 50% need an interpreter, and many of our clients have mental health issues. So we have to adapt our services to be able to provide a proper legal service to these people, and that includes us providing a lot of outreach. So I go to a place called Bill Cruz in Sydney, Bill Cruz Foundation, where homeless people attend, provide legal services there. We also provide legal services, for example, at mental health institutions.
Thanks, Danny. I'm looking through our questions, and I'm just going to come back to an earlier one that I'm quite interested in, and I think this is for Magistrate Hayes. If a matter is going to a hearing, so that somebody's, if in a criminal matter, is pleading not guilty, how do you determine how long that case is going to last?
Look, a great question. And it is difficult, but the court relies very much on both the prosecution and the defence to estimate how long a matter might take. A matter might have a whole lot of complexities for various reasons. There used to be the rule of thumb that you would allow half an hour per witness. So if there were 6 witnesses, you'd put 3 hours. And I'll be interested to hear what Danny and Jeremy might say in regards to that rule of thumb. I still sort of operate pretty much that way. But matters, for example's sake, involving sexual assault, where you might have a complainant, a young complainant, it's very, very difficult to work out with the constant breaks, the trauma of giving evidence, etc., how long a matter might take. So you're a little bit guided by the nature of the charge, but the defence and the prosecution are best placed in regards to some of the complexities in relation to witnesses, where matters may need to be allocated more time. But half an hour per witness is my answer. Jeremy or Danny, what do you say?
Yeah, it's just a matter of, as a Magistrate Hayes says, just experience. Having done 1,000 hearings before, you pretty much know how long it's going to take. I look at each witness, I think, what are the key points that I need to get out of them? Obviously, it can blow out if they're not giving you the answers you want, and you have to keep going at them for a while. But in terms of the estimate, depends how honest I want to be here with Magistrate Hayes on the line. But look, you never want to underquote the estimate, because if I say it's going to take 2 hours and it actually is going to take 6 hours, then we're not going to finish on the day, and the court might not have another day available for 2 months. And so I do a real disservice to my client. If I am feeling a little bit cheeky and I want to get a date sooner rather than later, I might estimate on the lower end what I think it's going to take to get that date. No. Look, I'd never do that. It has to be within the range, obviously. But no, you never want to underquote it, because it does a real disservice to the client and to the court if there needs to be a 2-month break between the next day that the court can hear the matter. So it's really just a matter of experience, and we usually know roughly what it'll take.
That makes sense. Danny, did you have anything to add to that?
No, not really. I think that was covered.
Well, good. Sorry, it sounds like I'm jumping around a bit, but I just want to make sure that we get to all the questions. Danny, I guess this is probably a question you might know, and it's back to tribunals. What qualifications do tribunal members have? And we talked a little bit about appeals before. What's the process if you're not happy with a decision, a ruling in a tribunal?
Okay. Let me talk about the Administrative Appeals Tribunal because I've appeared there more than everywhere else. If I go back to the example of Social Security law. So first off, it's a specialist tribunal, so the Social Security Appeals Tribunal, when it existed. The Administrative Appeals Tribunal now has 2 levels, and the lower level has specialist areas such as Social Security law, and people on that tribunal, the lower level tribunal, the Administrative Appeals Tribunal, may be drawn from Centrelink and may not have a law degree, or they may have a law degree and have experience in Centrelink as well. What I've found, and I've represented in these tribunals over a course of 20 years, that increasingly people on tribunals will have law degrees, but if they don't have a law degree, they'll be an expert in that area. So they may have worked for Centrelink for approximately 10 to 15 years before going on to that tribunal. In terms of appeals, let's go through it basically. Generally in government departments, and this includes when I've done freedom of information requests with New South Wales Police, but there's a couple of appeals that one can go through within the government department. Then if a person's not happy with that, can jump to the tribunal. And so then one would go to, for say, a Centrelink matter, to the lower level of the Administrative Appeals Tribunal. And then if not satisfied with the decision of that part of the tribunal, then an appeal can be lodged to the top level of the Administrative Appeals Tribunal. I also understand there's 2 levels at NCAT. Then in certain circumstances, and I'm more familiar with the Administrative Appeals Tribunal, in certain situations, an appeal can be lodged to the federal court about the tribunal decision. And if in NCAT, my understanding, to the Supreme Court.
Thank you. Did anyone want to add to that? No?
Not to that. That was comprehensive. I did just want to throw a bone to whoever asked that question as well about the rules of evidence, as His Honour did. It's really just about ensuring that the evidence that comes before the court or the decision maker is of a particular quality. You just, from your everyday life, you might have heard things like hearsay, but if person A hears something and they tell person B, who tells person C, who tells person D, well, the person who should give evidence in court of what happened is person D. They've heard it third hand. They're not a reliable source of what happened. And so the court would really just say, look, it should be person A who's giving the evidence in court. And that's just kind of a snapshot of just ensuring the quality and reliability of the evidence, I would say. That's just an example.
Thanks, Jeremy. So I understand Magistrate Hayes and Jeremy as well, you both need to get back to court. Is that correct? Yes. So we are going to end this webinar at 2 o'clock. And I just wanted to ask you all a final question. There are a few more questions that are maybe more detailed that we can respond to people by email. So we will address those. But as a final question, what, I guess, is one key message you have for people in New South Wales to know about either your role or the legal system in general? What's one key message you'd like to leave us with, Magistrate Hayes?
Well, look, that's a
hard question.
a great question, and it's got some complexities. But firstly, I'd like to say that, and I'm glad that you asked about a role, because there is no role more important or less important. We all come to a justice system with our individual obligations, be it a prosecution, be it a defence, or the impartiality of a decision maker. So we've all got roles, and as I say, it's essential that we all operate in accordance with those roles to our best capabilities, because the legal system, or what we call often in crime an adversarial system, only works if you've got good, committed, quality persons advocating on behalf of the party, as I say, whether it's the prosecution, whether it's the defence, or whether it's the impartiality of a decision maker. The rule of law is so essential in our community, and when you look at those countries which do not operate as wonderfully as this country, it's because they don't operate with that rule of law as being sacrosanct. So our roles are all very, very precious, and that we need to ensure that the quality of persons like Jeremy and Danny and myself and others that practice in the justice system are persons who are committed and have the qualities of ensuring that ultimately the community is protected, because they're able to fulfil their role appropriately, which includes, of course, holding governments to account, holding police to account, and ensuring that all persons, as I say, can operate safely in the community. Thanks, Natalie.
Thank you. Jeremy, do you want to go next? What's
I would just
the key message?
completely echo that. The only key message then from a defence barrister is just to always remember that just because somebody is charged with an offence, it doesn't mean that they're guilty of the offence. That's my key message.
Can I, sorry to interrupt, Danny, there's, this might be a complicated question, but probably something that's relevant to your work, Jeremy, is how do you, I guess, educate yourself around working with the client who might have a cognitive impairment in court? Is that just not going to take too long? Or I know it's so important. We've got a lot of disability support workers and workers on the webinar.
It's a long answer. It's exceptionally difficult. The pace and the crushing numbers in the local court make it exceptionally difficult. And it's very, very common. And I don't have a great answer for you on the short notice, but it's something that's difficult and you just really have to be aware of, and just something that experience teaches you, I think.
And if I could just add, and I know that Jeremy is well across this, there are a whole lot of mental health diversions within the justice system as well. So there are some matters that need to be dealt with in accordance with the law, but there are many, many matters which are able to be dealt with by way of diversion into mental health treatments. So there's a great flexibility that comes with the law, but that of course doesn't undermine the significant challenges that Jeremy and Danny and those at the Coalfront have when taking instructions and making some assessments in regards to persons' cognitive or other sorts of ailments that they may have.
Thank you. And Danny, what's one key message you have about your role or the legal system?
Well, I think what Magistrate was hit the nail on the head about the rule of law, and then what Jeremy said also about, I think it was person got the right to plead not guilty and test the matter in court. What I would say, coming from the perspective of Community Legal Centre, is that if a person has a legal issue and it's tricky for them, and it is tricky for them because they're not lawyers and they may not be familiar with the matter, is to try and get an understanding. Contact your local legal centre, or you need to speak to a lawyer to get legal advice about the best way to deal with it, because in my experience, it's one of the areas in life where people become very agitated, very upset, and it has a really big impact on their life. And so if things can be, dealt with early on, it's probably the best way to get a positive outcome.
That is such a good point to finish on, Danny. Thank you. And I haven't talked much about legal aid because we did that in another webinar, but I just want to plug for that. If anyone in New South Wales has any legal question, legal problem, the first point of call you can try is a 1300 888 529, which is LawAccess New South Wales, and they can refer you they can give you information or refer you for advice at Legal Aid or community legal centres or Aboriginal Legal Service or wherever is appropriate. Thank you so much to all of you today. I think we could have kept talking for hours, but unfortunately we had limited time, but I think everyone, including me, have learnt so much today. So we really, really appreciate your time. I know you're all very busy and all of you have just left court to come and talk to us today. So thank you so much. And I think everyone's learnt something today. So thank you. And thank you to Donna as well.
Thank you.
Thank you.
Thank you.
Thank you to all.